All right, we're
I would never.
we are
forget.
cooking with fire. We are cooking with fire.
Okay, we are live on Facebook and we are now live on TikTok. We're not going to do anything for a minute here though, because we like to just sort of, let people start to roll in even before we start the introductions.
Yeah. So
Okay.
for all of you out there, please be careful. There's a really bad rainstorm here locally, so be careful out there on the roads. We are waiting for people to join, and I am going to be sharing this to some of our pages.
All right, here on TikTok, we've already got some folks joining, Tammy and Caleb and Heather. This is great. Welcome, everybody. And then let's see, did we invite Odette?
Divine. Is Divine anywhere?
I haven't seen yet. I will.
Odette, are you up on the? Are you up on the?
I am.
Oh,
okay, all right.
All right, I'll keep an eye out for it. Okay.
So what do we?
And
So
we've got some folks on Facebook, so let's go ahead and get started. Welcome, everyone. Welcome back. My name is John Gardner. This is my law partner and wife, Radlyn Mendoza, and we are the immigration law firm Gardner and Mendoza. We come to you every Wednesday from 8 o'clock to 8:45 to bring you important immigration news. And we also answer your questions. So if you have questions about the topic that we're talking about, get them posted. If you have questions about anything dealing with immigration, go ahead and get those posted as well. We're on Facebook, we're on TikTok, we're also on YouTube. And I want to also warn you that what we do here is for informational and educational purposes only. It is not legal advice. All right.
wait, why is it not legal advice?
The reason it's not legal advice is because it would be really, really unwise for us to give legal advice with very limited information. You all are giving us these questions. We don't really know much about your case. We just know a little snippet of what you're telling us. We have to presume that all of it is true. And even then, there may be facts that we don't know about. So we can't possibly fully analyze a case with a simple question. And so we can't give you legal advice. If you want to get some legal advice, you're welcome to contact our office, become one of our clients, let us handle your case, and we will give you lots of legal advice. All right.
All right, fantastic.
We have a topic tonight. And before we get started, I want to introduce, I have an introduction, but I want to introduce Odette Batchelor, who is with us tonight, senior USCIS retired immigration officer. She brings a wealth of experience and information to this. So you get a great perspective. You get to see what's, the thinking on the other side of the desk. We've been immigration attorneys for over 25 years now, but it's always nice to pick the brain of the other person to know what's making them tick. What are these USCIS immigration officers thinking? What are they focused on? What are the red flags? So on and so forth. So with that, let's get started. We have a really important show for you. And I want to start by, basically acknowledging that I understand that you've been scared this week. It's completely understandable. There's been some news out there that I'm sure has made many of you very uncomfortable. The news that came out was alarming for those of us who are in the immigration world. And the headlines were even more alarming. And a lot of people in our community have been very upset, been losing sleep about it. And so tonight, what we want to do, Radlyn and I, along with our very special guest, Odette, is really break it down for you clearly, calmly, and honestly. We want you to really know what this is about and not just be relying on what you're seeing on TikTok or in news outlets and those kind of places. So here's what happened. Last Wednesday, USCIS issued a policy memo. It was policy memo 602-0199, and it changed the way that officers are instructed to evaluate green card applications filed inside the United States. And what the headlines were saying was that USCIS was ending green cards in the United States. That is not what the memo says. Yes, the memo is serious, and yes, it is very significant, but it is not the end of adjustment of status that is green cards in the United States. But what it does do is shift the burden. For decades, if you met the eligibility requirements, then approval was generally expected. However, under the new guidance, meeting the requirements is no longer enough. You now have to affirmatively show that you deserve the benefit. That's a real and meaningful change, but it is certainly not a ban on green cards, certainly not a ban on any kind of adjustment of status. Okay, so that's the first thing that we want to lay out is a burden shift, yes, but this is not a ban. And here's what else you need to know tonight. The same day that the memo dropped, USCIS issued a partial walkback. Basically, they issued the memo, and then they said, well, people who provide economic benefit or serve the national interests may be able to stay on their current path. So they basically put out this memo. They instantly walked part of it back. This created chaos and confusion. That tells you a little bit about the policy itself, the way that it was rolled out, that maybe it was a little hasty, maybe not thought through as thoroughly as it could have been or should have been. And, I can tell you with 100% certainty that there will be legal challenges coming. There are lawyers out there who it's all they do all day, every day is challenge these types of things. And I have no doubt that those cases are being filed as we speak, and we will keep you posted as soon as the first decisions on those start to drop. So what are we telling our clients right now? We're telling them to not make any major decisions, especially about leaving the United States, without speaking to an immigration attorney first. For many people, leaving the country triggers a 3 or 10-year bar that will then make it impossible to come back. So the administration is saying, go apply from your home country. That's fine, no big deal. But what they're not telling you is that is a potential trap, because when you go back to your home country, this may trigger the bar, and now you're going to be unable to come back into the U.S. All right.
Right.
So we've been doing this for 25 years. We have read the memo carefully. In fact, Radlin was rereading it for about the 10th time.
I don't know about 10
just
times.
before we came on. I said again. She said, yeah, again. All right. So we've been looking at it very carefully, and also brought Odette here tonight because, again, she has been on the other side of this as a USCIS officer, and she can tell you what it looks like from the inside, and what it looks like from USCIS when they get a new memo that pops. How do the offices react to it? How do they implement it? How quickly do they implement it? How rigid are they in implementing it? So on and so forth. So Odette, thank you so much again for being here. It's always great to have you, but especially when we have an issue like this, we're really, really lucky and fortunate to have your expertise and insights. So welcome, welcome.
Yes, absolutely. And so, guys, yes, thank you so much, Odette. And Odette has been, she's been with us for 4 or 5 live streams. She's done a webinar with us. Odette also is with us on we had an emergency meeting about this on Friday, and our team also needed her insight and her. I mean, we can call it inside ball, but not in a way that in a positive way, right? Like to hear from an immigration officer, a retired immigration officer who's a supervisor for the longest time, on what you should do, how to prepare your case, what are the things that you should include, what are the things that you shouldn't leave out. And it's not just coming from us. So I think a lot of people think, okay, well, they're immigration lawyers. Yeah, of course they're going to say that. But hearing it from a former supervising immigration officer who worked for USCIS and Legacy INS for 42 years, right? Tens of thousands of applications. This is experience that you're not going to get anywhere else but here. So let's get into some of the questions and some of the issues. Do we have any questions that are pertaining to this before I get into the questions? We like to go to the very front of the questions? I saw my name mentioned there. A little worried about that in the comments. Odette is also taking a look at the comments just to make sure that
I'm still
we're
looking
not
to,
missing anything. But
the very first question is just about if you know how long the 601 waiver is taking currently.
I don't know. I'd have to take a look at that. I'd have to look it up, but I don't know off the bat.
Did you invite me in to the TikTok?
That's what I'm looking for. I still don't see you here. Did I miss you?
You missed me.
Invite. Okay. Well, if we see you, we'll.
Yeah, you guys keep going, and I'm going to keep looking for you, Odette. And as soon as I see you, I'm going to invite you to join.
Yep.
Okay. So while you're.
Go.
Yep.
I see you now.
Invitation sent. I think we need to maybe turn the volume all the way down on that. Yeah. Okay, guys. Perfect. Perfection.
All right.
All right. Okay. So while we're waiting for the first question that pertains to this and just scrolling through, Odette, in your experience as a supervising immigration officer and just all of your decades of service with USCIS, when a memo comes down like this, like how quickly are the immigration officers, the supervisors able to make the change, right? How quickly, like something like this, for example, what are your thoughts on that?
I will tell you that most of the time we get memos coming out about how to adjudicate an application or what's the next process. It's done immediately, but immediately, meaning that very morning, they'll have a quick meeting about, hey, this is what we're going to do from this point forward. But because there's so many questions from the officers themselves, just like the people who file these applications, they want to know which type of adjustments are we looking at. So the supervisors will actually let us know then, hey, everything's going to be put on hold till we get a clear direction on what adjustments can be processed first, which ones are we waiting more clarification on.
So that said, you think that maybe there would be a short pause here? We had our first immigration interview. Attorney Sampson went to the immigration office in Norfolk on Tuesday, and do you think that because of this memo, there could be a short pause in adjudicating that I-45? I mean, your best guess, guys. This is not obviously you know, as John mentioned, this is not legal advice. This is not something that is definitely going to happen. It's just our perspective from our experience of our years with working with the USCIS, and again, Odette being a veteran immigration officer, supervising immigration officer. What do you think here with this?
If it was a case that had already been vetted through, that they said, okay, these cases are okay to go through this type of adjustment, then yes, it would be probably processed just like all the rest. But again, it could be a pause depending on the type of adjustment that has been cleared. There are some, I'm positive, there are some that are still getting further clarification on processing.
Right. Okay. So what happened, Attorney Sampson, our attorney at Gardner Mendoza, one of our attorneys, the officer told him that they, as you just said, they don't have enough guidance, right? I mean, because I don't think that the officer used confused. I'm sure the officer would never say, oh, we're confused about this, but that they're waiting on additional guidance to make sure that they are making the right decisions on these cases. Because what does this memo mean, right? USCIS's press release said something pretty different than what the actual policy memo said. And it is causing, as John mentioned, just mass confusion. So I know that just from being a member of American Immigration Lawyers Association and being on getting emails and being involved with the organization there as the liaison, I know that other immigration attorneys who have gone to interviews, they had a little bit of a different experience than Dom did, right? The immigration officers on Friday afternoon hit the ground running with questions about intent and whether they have family members back in their country and why do they choose to apply for adjustment of status versus consular processing. So these reports seem to indicate that some immigration offices are asking these types of questions. Whatever the answers were, we really don't know what the outcome is going to be, right? And one of the things in this memo, Odette, is that the immigration officer is supposed to, if there is a denial, to write the reasons for the denial and a detailed description as to why the case was denied and what factors. That's not unusual, correct? I mean, you guys just
No.
denied, and then you don't send a blank piece of paper to say denied. What is the process when immigration denies an application? Like, tell us a little bit about that.
Well, they have to have a reason. Like, you just can't deny the case because you didn't like the way they looked or you didn't think that. They have to have reasons based on law. Like, what law is being broke that they're not following, that they would have to deny the case. They will normally send out a notice of intent to deny first for an adjustment case and give you reason to explain why X, Y, and Z did not meet the standards of what USCIS is looking for. So if you can prove, the burden of proof is on the applicant. If you can prove that, yes, I did this and this is why I did it, and I have proof that I completed X, Y, and Z, you could overcome that notice of intent to deny and your case could be approved. But if it's a denial based on things that they found in your records and you admitted it, but you clearly knew about it, that's going to cause a problem.
Right.
But they do have to put it in there.
Okay. Good insight. Let's see. Any questions?
Yeah. Do you know if F1 applying to NIW will be affected?
Yeah. I mean, this is a great question. So if you're an F1 status and let's just say you're F1, again, guys, this is not legal advice. This is for informational purposes only
and educational purposes.
And please feel free to reach out to us so we can give you a proper evaluation of your case. But I'm just I'm speaking out loud here. But if you're on an F1 and your OPT is about to expire, so your F1 you will no longer be in F1 status, say by the end of fall, and you filed a national interest waiver case, and you concurrently filed your I-45 because you're able to, because it's current. Yeah, what do we do there, right? If at all possible, we're gonna try to have our clients stay in status while that's being adjudicated. So for some people, that's going to be an extra $50,000-$60,000, right? In foreign student tuition. So is that a hardship that we can take a look at? Is that would USCIS consider that to be an extraordinary circumstance that they would then go ahead and allow the adjustment of status to go through? See, we don't know that. So if at all possible, we're going to try to make sure that our clients are in the safest possible situation. And we would probably say, hey, you should probably, if you can, stay in F1 status, right, while you're going through this. But so many people may not have that opportunity to do that. And so it is quite unfortunate. Many people they're kind of in a limbo situation, darned if you do and darned if you don't. And it's causing obviously a huge disruption and concern in the community. So really great question. Call us because we're working on cases just like that right now. All right. A couple of questions here on Facebook. I'll pull it up on the screen. Honicia says, what if you filed an I-130 petition since 2020 and the status is still pending? I mean, I would be concerned if we're talking about, an I-130 petition for a close family member. You're a U.S. citizen, you filed for your spouse, you filed for your parent, you filed for your underage child under the age of 21. For F2A cases, I would be concerned. Maybe, maybe not so much if you filed for your sibling. And Odette, I don't know if you worked on these cases at the service center where somebody has filed an I-130 petition for a sibling, for example, and it's 15, 17-year wait. I mean, how quickly is USCIS going to approve that I-130 petition is definitely not a top priority. So
yeah, they're usually one of the last ones that get processed
right.
for the fact that there's no visas available.
Right. So there's no reason to go ahead and just approve it. We've got other more pressing cases where they're immediate relatives of U.S. citizens or maybe F2A category. So it could be perfectly normal. Honisha, give us a call and let us take a look at that. We'd be happy to give you our 2 cents on it. All right. Got another question over there.
Yeah, Kevin wants to know, how are SIJS cases processing? My priority date is 3/21/22, and I submitted my adjustment of status shortly after.
Right. I mean, for SIJS cases, like there's no going back, right? There's that. I think there's I'm not going to say there's an exemption here. There's nothing that has been specifically carved out from what I've read. And again, this broke on Friday, which was just a few days ago. But what else can SIJS do other than adjust their status? And I have seen other, writings and postings where, SIJS is going to be in the category where adjustment of status is really the only option that's available, and consular processing is not available. Similar to, I got a question about K1s the other day. That the K1, and the person was really scared, right? They said, okay, I don't want my fiance to come here and then we get married and then we're gonna have to start this whole process over again. And when you read a memo like this, because I thought, well, no, I mean, that's K1, right? You have to adjust your status. That's the whole purpose of the K1 visa. But when you read a memo like this, it does put people into a state of panic. And they think, okay, does this apply to my K1? Like, could it, should it? And then I kind of started second guessing myself, like, is it possible that they would even apply this to K1? I don't know. I don't think so, though. I mean, I'm going to say hard. I'm going to say I strongly believe at 99.9% that K1 will not be affected by this. I think that SIJS cases, you cannot adjust outside of the United States. You cannot do consular processing. You have to adjust within the United States. And so these are things that I will develop as more days pass. And definitely there's going to be litigation around this, 100%. 100%.
Yeah, I mean, just not just to plug attorneys, but again, this is just more reason that if you are in this process or about to start this process, that you really should have legal counsel, because things are changing all the time, and it's important to have people analyzing it who know, what they're analyzing and what the impact's going to be. So even if you're in the middle of a case already, I would reach out. If it's not us, that's fine. If you don't like us for whatever reason, or you don't feel comfortable with us, or you want
How could that be possible?
Or if you want somebody that's more local to the market that you're in, I get that. But you should definitely talk to somebody. It's worth investing a little bit of money to make sure that you know what's happening in your case.
Yeah,
before you
absolutely.
make a mistake that could really be a serious one. I mean, there are a lot of landmines in immigration law, and you want to make sure you don't accidentally do something that's going to be fatal to your case without realizing it until it's too late.
Right. Or as I like to say, don't step over $100 bill to pick up a penny. And that's how I truly feel when people say, well, I wanted to save money, so I didn't use an immigration lawyer, but
Yeah.
can you please take a look at my denial?
Mhm. I wanted to save money by not using an immigration lawyer. So, the case finally got approved, 4 years later, when it could have been approved a year later if I'd done it right. So I lost 3 years of being able to work in the United States and, make a better wage. But, that's up to you. You folks do what you want. But I would recommend an attorney.
Yeah,
100%.
we are being serious, because I was about to say, in all seriousness, this is not the time to not have counsel,
It's
right?
really not.
I mean, okay, fine. Maybe there were times to not have counsel. So this is our profession, right? Just like Odette is a retired immigration officer who has been an immigration officer for 42 years. This is what we've been doing for the past 26, right?
Yep.
26 plus years. This is what we do. We represent people going through the immigration process. John was a criminal defense attorney. He retired from that. He started doing immigration, but he retired from doing criminal defense after 20 plus years. And a lot of his cases dealt with non-US citizens. A lot of his cases dealt with marriage fraud. So these are all things that come up in the practice of immigration law. And so you need to have experienced people to be representing you. And as John said, this conversation is not, oh, okay, let me get as much information as I can from all the TikTok lawyers out there and do my case. No, we're all here to help you understand that you need professional counsel, a professional immigration attorney to help you. So, okay, moving on to the next question.
Wayne wants to know if you can guide him or her on how to sponsor caregivers from the Philippines for their growing home care business.
Absolutely. We can 100% give you guidance on that. We represent
they have
people.
3 branches in New Jersey.
Yeah.
That's good.
Congratulations on
one
your
in Nevada and one in Seattle.
Yeah, congratulations on your success.
Yeah.
Here's the thing that I want to tell people who have growing businesses, and here this happens a lot. There's a caregiving business, and they need people, right? They need people who may or may not need the credentials, but can easily get them. You have to be like, look into the future, right? You can't say, okay, I really need help in sponsoring 20 caregivers with X, Y, and Z credentials. And then the immigration lawyer says, okay, there's a 3-year wait. Don't crumble up and go away, right? Because you're still going to need those workers. I mean, if you're growing. So a lot of the times I have these conversations and we do these consultations and we talk about the wait and how long that it takes, right? 3+ years. And, half of the growing business, like, oh gosh, that's going to take too long, right? 3 years is not a long time. It is not a long time, and we can certainly help you with that. That would be my number one recommendation, is this is for your future. This is for your business's future. It sounds like it's a really bright future. And that's what you have to think. That's how you have to think when we're bringing people over here who are, potentially permanent workers, permanent quote unquote workers who you're sponsoring, you're going through this process with. You're helping bring them here and their spouse and their children on the age of 21. So this is a huge benefit for you and for them. And so there is a little bit of, there's loyalty there, right? So just think about the future, and we can certainly help you with that and go through those steps. It's very exciting. I mean, it's great when we're able to help a business grow with workforce and people that, they appreciate and that appreciate them.
Yeah, take it from a 57-year-old. 3 years is like that.
Goes by really fast. Yes.
When you're in your 20s, 3 years seems like it'll be a long period. when you're in your 50s. 3 years seems like another 3 just slipped past and you don't even know what happened.
Yeah. I'm going to grab this question here really
Okay.
quickly. It's from Emma. And Emma says, is the process going to be more difficult for NATO visa holders being married to a U.S. citizen? So here, again, we have the situation where, somebody's is in a visa type, you have the NATO visa. And what is this policy? Like, what does this policy memo mean for people who are going to be adjusting their status? I mean, presumably the person on the NATO status is going to be in that status up through their immigration interview, right, Odette? I mean, you've done NATO
Correct.
Interviews, so you're still in status. There was a footnote in that policy memo. I might have been footnote 20, but it was regarding H-1Bs, which is, of course, a dual intent visa, where you can have the intent to immigrate to the United States. But anyway, that that footnote basically said, just because you have been in your H-1B status all this time, and then you go to adjust your status, does not mean that we're not going to go make you do consular processing, right? Who read that footnote and fell out of their chair when they read that, right? That's insane. That's absolutely crazy. So, Emma, if you weren't here when we started, there was a little bit of walk back. If there is going to be an economic benefit or a national interest in the United States, if the applicant can show that, I don't know what that means. That could mean a whole lot of things. We're lawyers. We can make anything an economic benefit or to help the national interest, right? I mean, that's what we do. That's we can dig and find, right, and show how amazing our clients are. So is it going to be difficult? I think there's just going to be additional questions about whether do you have family members? These are the questions that I've read and heard, right? Do you have family members in your country? Why aren't you consular processing? Why are you doing adjustment of status? Did you know you're going to be doing adjustment of status when you came in the last time you came in? What was the intent? What did you tell them when you came into the airport? Again, you're probably not getting a lot of these questions when you come in through your NATO visa, but you could be. And I'm not going to say it just might be different, not necessarily more difficult. Odette, what do you think?
Oh, I agree. They definitely will be probably asked all the questions. The actual intent, like, did you already know this person before you came here on that NATO visa? Are they a child of the NATO person, or are they actually like a NATO 1 or 2?
Yeah, right.
It's a lot of questions.
Right. And so maybe they are the child, right? And maybe they've gone to high school here. Maybe they've lived so many years in the United States and they've fallen up in love with their college sweetheart. I mean, why would we send you? And let's just even say they have a baby to throw it in the mix, because this is the reality of the people that are going to be impacted by this and say, no, you need to leave. What about my baby? Well, your baby's a U.S. citizen. Baby can stay here, right? Baby can stay with dad or mom. And that's splitting up families. That's completely unacceptable and un-American, for that matter. So, okay, next question.
Okay, XH wants to know, has no questions, but would be interested on your take on this new memo. Do you think it will change much? That's exactly what we've been talking about. I don't know when you came in, but just keep listening, and that's what we're discussing. And if you came in late, then you can always revisit this and watch it again later. Okay.
Okay, let's do a reintroduction really quickly.
Yeah.
You want to reintroduce this while I deal with this situation here?
8:45 is the expected arrival time of my reintroduction. 8:45.
Okay.
My name is John Gardner. This is my law partner and wife, Radlin Mendoza, and we are the immigration law firm Gardner and Mendoza, and we are celebrating we're actually
26.
26th year now. We were celebrating our 25th anniversary. That was a lot of fun. We're now in our 26th year, and we are also joined, as we are most Wednesdays now, luckily, by Odette Batchelor, who is a retired senior USCIS immigration officer, giving her perspective on all of these things. And so, yeah, bring your questions. We've been answering them. We have more here.
Thank you at Boss Babe. Appreciate that.
Yeah, we've got hi from California. Congratulations. Thank you. And, we have people joining. I just will piggyback off that. We have clients all over the United States and all over the world. So it doesn't matter where you are. We will meet you where you are. We do everything through Zoom, DocuSign. Immigration law is federal law. So we do not have to be barred in every state. We only have to be barred in one, and we are. We are barred in Virginia. Our office is physically located in Virginia Beach, Virginia, on the East Coast of the United States, but we do have clients all over the country. So, yeah, no matter where you are, if you want to give us a call and have a consultation, and we'd be happy to talk to you. And Boss Babe, you're very welcome. Says, appreciate you all doing this. It's our pleasure. We've been doing this we've been doing immigration law for over 25 years, but we've been doing these lives now for 6 years. This all started when COVID hit, and we wanted to try to find a way to get information out to our clients and to our communities. And so we started doing Facebook Live, and it just kind of stuck. And here we are 6 years later.
Yeah, we did it. The first one was on my birthday. I don't know if you remember that. We were on the couch. I would love to pull that up. It's probably deleted by now.
Yeah. I was going to say they used to be a lot more informal. We'd be sitting on a screened-in porch in flip-flops, talking about all of the new the bans that the governors were like issuing these executive orders every other day about how many people could,
right,
be in town halls and how far apart they had to be and all that stuff. Okay.
Let's grab a question on TikTok, and we've got a couple here on Facebook as well.
Yeah, Natalie wants to know, I'm on an H-2B visa that expired on July 31st. Children are U.S. citizens in the Army. What are my chances to adjust?
Wait, hold on. Can you go back up?
Yep.
Okay. So we have a person who is on an H-2B visa, entered with inspection. That's important, right? Entered with inspection. They've overstayed their H-2B visa from how I'm reading this, and they have U.S. citizen children in the Army. Let's assume that the children are 21 or older. Okay. I mean, maybe they're not, maybe they're younger than that, but the law is that, well, there's a new policy, but it is a policy, right? But a person who has entered the United States with inspection, such as an H-2B, and is the parent of a U.S. citizen son or daughter, 21 or older, may be able to adjust their status, right? So definitely reach out. And I think that maybe the question here is, okay, should I be going through this process right now, right? Should I be going through this process of adjusting status with this new policy? And this is a perfect example, right? Say this person read the memo. It's like, oh gosh, my kids are going to apply for me. They're in the military. They're in the U.S. military. They have their mom here. And, maybe their children are maybe their children's deployed, right? Who knows? And it's extremely stressful for them to have mom who wants to go through this immigration process. And she reads this and she's like, you know what? It's not going to work. It's this memo says everyone's got to go. I'm going to go. So mom is going to go. Mom's going to trigger that 10-year bar if she's been out of status for over a year, which I believe from this question is she is. But if that's not the case, let's just assume she's going to trigger the 10-year bar, and there's no waiver for her to come back in. She can't come back in. There's no waiver. Children are not a qualifying relative. So what do we do, right? What can you do? I mean, mom is here in the United States. What do? Do we roll the dice and file adjustment of status? And we've got this ridiculous policy. do we roll the dice and give this mom permanent residency and allow her to be here to support her U.S. citizen children who are in the U.S. military, right? So give us a call, please. I mean, I'll tell you that, we're still filing adjustment of status applications because in situations just like this, there's really no other choice, right? They can't consular process. And maybe that's a carve out. Maybe that's a reason why that the officers are going to approve adjustment of status cases because you can't consular process it because of the 10-year bar, right? What do you think about that, Odette? Pipe dream.
That would be the case, but I think she says she doesn't expire until the end of July. So she actually has some time.
Okay. So,
and I think there's going to be so many more changes coming up long before July about this memo too.
Good point. I missed that. But so and here is where you need.
It's unclear whether she means that it's expiring this July 31st coming up that you
right,
or that it expired
past
last July 31st, in which case she's not up to a year yet.
Oh, right. Yeah.
She's not up to a year yet. So this is where we have to make the tough decisions, right? This is where you sit down with your lawyer and you talk about the strategy and you say, look, you do have a 3-year bar if you've been out of status since July, but you don't yet have a 10-year bar, right? Because you haven't triggered it yet potentially. And again, I'm just going by little snippets here. What should we do? Should you go back and maybe come back and forth on your H-2B still, and your son or daughter or children, one of them files an I-130 petition for you, right? They're U.S. citizens. That's taking it'll probably take about 3 years. The 3-year bar is going to be gone by then if there is an actual bar. So there's just a lot of strategy and analysis that needs to happen here. And it's not something where, you can be like, okay, well, I'll just file the I-130 petition and see what happens. Or I'll do a one-step green card application and see what happens. I mean, there are real implications here, and you may not want to take that risk, right? A person who may be in status may not want to take the risk of adjustment of status during this time. But you want to be able to have that choice. So please give us a call. It doesn't matter where you are, as John mentioned. We can help you. All of our initial appointments are virtually. If you're out of the country, if you're out of town, then all of them will be. We've done it for many, many years very seamlessly. So please give us a call. And if you don't give us a call, Mom, give someone else a call. Give another reputable immigration attorney a call and find out. Don't keep guessing, because if you're still in status, if you are went out of status in July and it's not been a year yet, it's almost a year, you do have some options. That does not necessarily mean that you have to apply for adjustment of status. I mean, if we didn't have the policy memo, we'd be adjusting you left and right. But now we do have to think about these things. Yeah. I want to ask Odette a really quick question before, and I know we're running, we're at time here, but the memo, it requires officers to weigh totality of the circumstances, right?
Yes.
Where, is that something that you all have training on? Do all immigration officers have training on weighing totality of the circumstances? It's not something that we traditionally do for adjustment of status cases. So I'm just curious to know the type of, whether immigration officers are trained on totality of circumstances, whether they be like a refresher. Tell us a little bit about that, if you can.
The officers that have been there for a while have had that training, in-house training.
Right.
Definitely would do refresher. The newer officers are going through training probably as we speak, because they're hiring so many new people now. And I will say that before they make any of these decisions on any of these cases, if they're not, they will do a quick training on that. So they do have days broke out just for training. I think this memo is going to take up a lot of that training.
Gotcha. And is it the supervisors who normally conduct that training? I know you've done a lot of training for new officers, and
we do have the supervisors will do it, the training officers will be involved, and also our legal counsel will be involved.
Okay. All right, fantastic. This question's been sitting here for a sec, and I'm gonna just grab it just because.
All right, we can end with this one if you.
Okay, this is Mickle.
Yep.
You read that.
Entered.
You know how terrible.
Entered on a B2 visa in 2018, and then left. Re-entered in 2020, then got an extension, then on F1 status,
and then filed an F1. So I've got a B2 extension.
F1 status. Okay. Under F2B category family, I could file in 2023, but I preferred consular processing. But in 2025, I did due to the war in Lebanon.
Okay. I don't think I understand the question.
I don't either.
I don't understand what the question is. Or maybe it's just a statement. I mean, F2B category is long also. Like if you filed in 2025, it's certainly not going to be current.
Yeah, okay. That's tough. Why don't we end with Grace here instead?
Give us a call. Mickle.
Yeah, we need some clarification on what the issue or the question is. Grace wants to know, we had our interview a day before the memo. It was approved, the I-130, just waiting on the I-485. Will this affect us?
You know, I came out strong on Friday and made a video and said this is not going to affect pending cases. It is affecting pending cases. The questions are being asked, and even though you had your interview, I think I don't. So Dad, I'll defer to you here. If a person has their interview, an I-45 interview, so the I-130 petition has been approved. This seems to be a trend, right? The I-130 petition is getting approved first, and then the I-45 is getting approved later. For many years, they just kind of were approved simultaneously, and then the green card was issued. But here, Odette, they've had their interview, and what do you think is? Odette is guessing here. What do you think?
I'm going to say that application is probably on pause right now.
Yeah,
because the memo came out. Everybody's still trying to grasp on exactly like what type of 485s are the ones. Right. So this is an I-130. I'm going to assume a spouse or child.
Right. Yes.
I would say that if anything, since the I-130 was already approved, they may, after reading the memo, decide, oh, well, you didn't ask these specific questions. You might need to call them back in and do those questions before we make a final answer. That could be what they say.
Okay,
or when they get clarification, it could be approved.
Mm-hmm.
Could it be an RFE potentially, like an affidavit? I don't know. Is that just the normal thing? Just let's call them back in and ask these 3-4 questions, and as opposed to an
RFE. It has been. We have done that. Yeah.
Yeah, it doesn't make sense to do an RFE and just be like, hey, answer these questions under a sworn statement, affidavit. Okay, that was right.
Yeah.
So you're basically saying that depending on how this memo goes, these folks might be, or the beneficiary might be called in specifically for certain questions that
Correct.
that are related to this memo. Okay. All right. I hope that's not the case, but
yeah, if you want some more guidance, Grace, give us a call.
Yes, and I did see someone ask the question whether we do file review. That is something that we are starting to offer, but under very strict parameters. So give us a call and we can tell you a little bit more about that. So yeah, awesome.
All right, gang. Don't freak out. Just stay calm, and we will keep you updated. We'll be here again next Wednesday, and if there's anything more that we know about it, obviously we will let you know. Hopefully, Odette will join us again. Odette, thanks again for being here.
Yes.
Always a pleasure to
Thank
have
you so much.
Thank you.
We really appreciate it.
Okay, everyone.
All right.
Two
Two thumbs up.
Have a great night. Okay.
See you guys later. Take
All right,
care. Bye-bye.
Take care.